So good afternoon, everyone, and thank you for joining us. My name is Steph Kershaw, and I'm a research fellow at the Matilda Centre for Research in Mental Health and Substance Use. We are based at the University of Sydney, and I'm also the project coordinator for Cracks in the Ice online toolkit. It's my great pleasure to welcome you to today's webinar. So today, before we begin, I'd just like to acknowledge the traditional custodians of the land and pay my respects to elders past and present. I'm joining you today from the land of the Gadigal people of the Eora Nation, and this is their ancestral home, and I recognise their continuing connection to land, water and culture. I also like to further acknowledge the traditional owners of the country on which you are on today and pay respects to their elders past and present. So today is one webinar in a series focused around crystal methamphetamine for the Australian community, and it's running as part of the Australian Government Department of Health and Aged Care funded project Cracks in the Ice. Before I introduce today's speaker, I just wanted to let you all know that as participants, you are in listen only mode, and that means that we can't see or hear you. However, you will notice that you have a Q&A button on your dashboard, and this is where you can type in any questions that you have during the webinar and send them through to us. And then after the presentation, we will have a short question and answer section. I'd also like to let you know that we will be recording today's session, and we will make the recording as well as the slides available to you through the Cracks in the Ice website, and you'll receive an email once that becomes available. So today's speaker is Jared Bartle. He's an associate lecturer within criminology and justice studies at RMIT University. Jared's a former criminal lawyer and drug policy consultant, and he specialises in legal issues related to illicit drugs and sexuality, including the limits of consent under criminal law. So thank you so much for joining us, Jared. We're really lucky to have you today, and I'm sure this is going to be a really interesting session. I'm going to hand it over to you now.
Thanks for having me. Bear with me 2 seconds whilst I get my slides up. So as Stephanie noted, my background is as a criminal lawyer who kind of frequently engages with the alcohol and other drug sector. And we were actually just having a conversation prior to this webinar starting about that there really needs to be more communication between the legal sector and the alcohol and other drug sector and people who use drugs. So I'm hoping this webinar will assist in some of that dialogue, because I think that's really important. So the title of this webinar, Meth and Sex, What Does the Law Say, is going to be canvassing the laws in relation to sexual consent and their relationship with what lawyers call the laws around intoxication. And the reason I think that this is going to be quite valuable for clinicians and people who use drugs is because of these potential questions that might arise. So I imagine with people who use methamphetamine in particular, there might be some conversations about experiences that they've had, and trying to situate that experience within the law of consent and deciding whether or not potentially a criminal offence has occurred is potentially going to be part of clinical discussions and also people thinking about their own use. So this question of, can I legally consent to sex whilst high? Can I still get into trouble if I was high at the time when some sort of sexual activity occurred? And what if we were both high at the time? What does the law think about that particular type of dynamic? I think it's important to start off with to acknowledge that I'm only going to be speaking about the criminal law and whether or not the thresholds for the criminal law come into play. And that's a very different conversation to whether or not a particular sexual encounter was harmful or traumatizing or, immoral. Those are separate questions to whether or not there are sufficient grounds to prosecute someone for a criminal offence. So I don't want anything that I say today to be construed as saying that someone's experience should be downplayed just because it doesn't quite reach a criminal law threshold. So why particularly is methamphetamine and people who use methamphetamine likely to have these questions? Well, we do know that people who use methamphetamine are more, I guess, sexually adventurous. They tend to have multiple sexual partners. They tend to engage in casual sex more, and oftentimes that is done whilst under the influence of methamphetamine. And we also know certain subgroups, particularly gay and bisexual men, tend to use methamphetamine within a sexual context much more often. Not a huge fan of that concept of chemsex, but that's certainly a feature that people may encounter. There's this frequent use of methamphetamine and then having sexual encounters. And so deciding whether or not certain thresholds in the criminal law come into play is quite relevant for methamphetamine. But a lot of what I'm talking about today would apply to all drugs. Just a quick legal disclaimer, other than this isn't legal advice, it's public education. There's a lot of change happening in the laws around sexual consent and sexual offences. Many of you will be aware that there is currently a national inquiry into current and proposed sexual consent laws. They're going to be reporting back in September of this year. And so some of what I'm saying may be out of date by the end of this year if there are substantial changes in the law. Some of what we'll be talking about today is some of the differences between each state and territories. And so something that might come out of this national inquiry is that we might have a uniformity in sexual consent laws across Australia. And so that might actually simplify our understanding of how sexual consent is defined under the law and how that would apply to methamphetamine. So just a bit of a background framing of what we're talking about in terms of the criminal law. So Australia works under an adversarial system where we have a prosecution and a defence. So if someone's charged with a criminal offence, it's the responsibility and the burden of the prosecution to prove beyond reasonable doubt each element of that offence. And we're going to look at the offence of rape in a couple of slides and look at some of those elements. I want you to keep in the back of your mind that each of those elements needs to be proven beyond reasonable doubt if that goes to trial. So any doubt and that element would not be met, and therefore someone cannot be found guilty of that offence. If you were ever wondering about where to find the relevant laws to do with sexual assault, rape, or sexual consent, I've got them out listed there. Most of our law is found in statute or legislation, which are kind of acts that you can look up to determine relevant offences. Sexual offences come in a variety of forms. There's the offence of rape, which requires sexual penetration under the law. And there are other offences that someone might be charged with, something like sexual touching or sexual assault, which doesn't require penetration. New South Wales is a bit of a weird one here in that they call their rape offence sexual assault, but generally in other jurisdictions, sexual assault is any kind of sexual touching without consent. And then we have obviously child-related offences where sexual activities with somebody under the age of 16 years of age in most jurisdictions, in some jurisdictions 17 years of age. So the offence of rape has a number of elements that must be proven beyond reasonable doubt. We're going to look at two of them in a bit of detail to look at how intoxication might come into play here. So for the offence of rape to be made out, the prosecution would need to prove that there was voluntary sexual penetration of another without that person's consent. And this is the bit that varies quite a bit between different states and territories, either with the relevant mens rea, guilty mind, mental fault element at the time, or without establishing the excuse of a mistake of fact. And we're going to talk about what that means a little bit later, but just getting used to some of this terminology here. So let's focus on initially that element of without consent. Lack of consent is obviously a key component of sexual offences. And so we need to think about how would methamphetamine intoxication impact proving or disproving whether or not someone consented. So First consideration is this idea of age of consent. So the age of consent is the age that we recognize under law that you can consent to anybody. And it varies across Australia. In Victoria, New South Wales, ACT, Queensland, Northern Territory, and the Western Australia, the age of consent is 16 years old. In South Australia and Tasmania, it is 17 years old. Now, in all of these jurisdictions, if the other party that the person is having sex with is in a position of special care or power, so that there's a guardian, a teacher, a police officer, a health professional, if the relationship is occurring as part of that relationship of special care, the other party has to be 18 years old. So it kind of ups the age of consent where there is a relationship of special care. In terms of sexual consent under rape laws or sexual assault laws or sexual touching laws, each state and territory defines it a little bit different. So in Victoria and Tasmania, sexual consent is talked about being a free agreement to sexual intercourse or free agreement to the sexual activity. In New South Wales, South Australia, the ACT and the Northern Territory, it is a free and voluntary agreement. And in Queensland and Western Australia, it's consent freely and voluntarily given. Now, they all overlap considerably, and they're not further defined in the pieces of legislation, but you can kind of get what people are referring to here when they're talking about sexual consent. So sexual consent has to be something that is freely given. That is, you cannot be coerced into giving sexual consent. And agreement envisions an idea in which someone knows exactly what they're getting into, so that somebody has some knowledge about the kinds of sexual activity that they're agreeing to before they start doing that sexual activity. So if you keep in the back of your mind when we're talking about sexual consent, that the ideal of what we're talking about, that the very idea of consent we're talking about is free agreement. It'll make sense why the rest of the laws kind of play out the way that they do. So key components of sexual consent in all states and territories in Australia is that consent can be withdrawn at any time. Consent on one occasion is not taken as consent to future acts, and consent to one type of sexual activity is not consent to another type of sexual activity. So that idea of a free agreement is an ongoing process. It's not that you make one decision to consent to a sexual act and you're bound by that decision. It is not strict and contractual in that way. It is an ongoing free agreement to that activity. All states and territories make it clear in their legislation or in case law, situations where there is clearly not consent, where there clearly isn't that free agreement. So if consent is obtained through force or threats of force, there's no consent. If it's obtained by fraudulent representation about the nature or purpose of the act. So for example, if the sexual act is consented to with a condom and a condom was not used, then you have not consented to that sexual activity. If a person is asleep or otherwise unconscious, they of course cannot freely and voluntarily agree to the sexual activity, and so that's not consent. If a person is mistaken about the identity of the person, or in some situations, if they're mistaken about the nature of the act, so if it's ostensibly put forward that the act is done for a medical purpose when actually it's done for sexual gratification, that's not consent. And finally, if a person lacks capacity, that is, someone as a result of a cognitive impairment or a mental health disorder is unable to freely and voluntarily agree to sexual activity. Now, these are just features that are shared throughout Australia. Some jurisdictions have extra criteria that they set where it's very clear that consent is not given. Some of you might be aware of affirmative consent and this idea of affirmative consent. In Tasmania, Victoria, New South Wales, and the ACT, they have reformed their laws so that they follow this doctrine of affirmative consent. And affirmative consent basically means that a person is not consenting unless they say or do something to indicate consent. Okay, so they've put in their legislation that if one of the parties doesn't say or do anything to indicate consent, then the law will say you are not consenting. Other jurisdictions haven't gone that far. They've said that not saying or doing anything doesn't mean that someone's consented, but they're not strictly saying that you do not consent if you do not say or do anything. It's a bit of a fine line, but you need to communicate consent in some way for it to be valid consent. And these law reforms make it clear that it's not just talking about verbal consent. You can indicate consent through your actions, through gestures like a nod, or reciprocating movements like removing clothing in exchange for somebody else. But there has to be some communication from the person. All right, so that was a bit of background on sexual consent. How does intoxication play into this? Just checking my time there. How does sexual consent play? How does intoxication play into sexual consent? Well, in all jurisdictions but Queensland and Western Australia, there is a specific section of their legislation which talks about when intoxication might vitiate consent or might mean that consent doesn't apply. Intoxication can still vitiate consent in Queensland and Western Australia, and it all goes back to that broad definition of consent freely and voluntarily given. If intoxication hinders that, then they didn't consent. So here's the wording in different jurisdictions about intoxication and consent. I won't read through all of them, but you'll note there that in all jurisdictions, there is a recognition that intoxication with alcohol or other drugs, so this includes methamphetamine, the mere fact that someone is intoxicated isn't sufficient to say that they lack consent. It's that they've reached a certain point of intoxication that means that they cannot freely and voluntarily agree to the act. So in Victoria and New South Wales, so affected by alcohol and other drug as to be incapable of consenting. And that's a theme that you see throughout all of the definitions, that the level of intoxication has got to the point that someone is unable to reach that threshold of free agreement. So does this include methamphetamine? Yes, it does. And we have cases recognizing this as such. So the vast majority of cases that we have to do with intoxication and consent are dealing with alcohol, but it does include illicit drugs, including methamphetamine. And we have one case of CLO, which makes it clear that it can include ongoing effects of methamphetamine. So not just the immediate high from methamphetamine use, but if you've developed, say, psychosis as a result of methamphetamine use, that can also be taken into account in deciding whether or not consent is vitiated. So what are some features of methamphetamine intoxication we should consider in deciding whether or not someone can no longer freely and voluntarily agree? Well, there's the general effects on cognitive functioning. So that people might have impaired memory, they might be more impulsive, their attention might be affected by methamphetamine. There's the particularly notable effects as a result of over-ramping or overdose. I know there's some contention about the use of those terms, but so they can include things like unconsciousness or even symptoms of psychosis like hallucinations. The effects of sleep deprivation, I think, are really, really relevant when we're talking about sexual consent. So the impaired decision-making as a result of lack of sleep. If somebody is unconscious, of course, that could be the result of sleep deprivation or an inability to focus. We have those hypersexual effects, that those factors that as a result of methamphetamine intoxication, which make people more likely to be sexually adventurous, be taking more risks, increased libido, and there is a documentation of kind of increased rates of sexual regret. And then finally, drug-induced psychosis is probably the most extreme impact as a result of methamphetamine intoxication, where someone actually develops psychotic symptoms as a result of their meth use. And so all of these effects may be relevant and something to consider in deciding whether or not it's vitiated sexual consent. So some general, I guess, guidelines in having these discussions about whether or not someone lacks consent. So being substantially intoxicated with drugs in itself does not mean that someone is incapable of consenting. You can't just point to the fact that you were high at the time or you were very drunk at the time as saying that that indicates lack of consent. What's required is that I was so high at the time or so drunk at the time that I was unable to consent. I was unable to freely and voluntarily agree. So if we go back to that definition of sexual consent that we looked at earlier, that idea of a free agreement, to say that someone does not consent as a result of methamphetamine use, we really need to say that it stopped them from freely agreeing or freely and voluntarily agreeing to the sexual activities. So in that case, some of the clear cases of non-consent that might arise from methamphetamine intoxication include if somebody is unconscious. If someone is unconscious, they cannot consent. If the methamphetamine intoxication means that a person does not understand the nature of what they are doing, then they cannot consent. Or if somebody is so exhausted or impacted by other effects of methamphetamine that they cannot withdraw consent, then that would be sufficient to say that there is lack of consent. And this is so contextual and individual, but there's some good signposts to start thinking about lack of consent. I should note that hypersexual effects, so the fact that methamphetamine increases libido and makes you more likely to take sexual risks, I can't see that being argued very often in court as indicating lack of consent, because if somebody has the capacity to understand what they're doing, they just have increased libido, that's not really reaching that threshold of not amounting to a free agreement. Someone might have a consideration of psychosis, and if someone's reached the point of psychosis, does that mean that they no longer have capacity to consent? I think that that's an interesting argument to put forward. Capacity has generally only applied to circumstances of quite severe cognitive impairment or quite severe mental health disorders, but schizophrenia has been recognized as one of those situations. Some of the key questions to ask to decide whether or not someone had capacity to consent as a result of psychosis is, did the person understand the sexual nature of the act that they were doing? And did they understand they could refuse sex at any time? They're the kinds of questions that tend to be asked in relation to capacity. So it all comes back to, in this element of sexual consent, it all comes back to whether or not the methamphetamine intoxication meant that someone could not reach this particular threshold. And so in discussions with clients, or if you're considering your own use here, the question for the law and for criminal prosecution is whether or not you are incapable of freely agreeing to the sexual activity. All right, so that was one of the elements of the offence of rape, and it dealt specifically with lack of consent. The other thing that may be considered, has to be considered in prosecuting any rape offence, is whether or not a person had the mens rea or guilty mind required for the offence, or whether they can bring up this excuse of reasonable mistake of fact. So there are different approaches to what I'm calling mental culpability in different states and territories. So in Western Australia, Tasmania, and Queensland, technically the offence of rape is proven if someone sexually penetrates another person without their consent, okay? That's all that's required to prove that offence. However, there is a defense kind of, there'll be some lawyers that will quibble with that idea. There is a defense available if the defendant raises evidence that they had an honest and reasonable belief at the time that the person consented, and that this was sufficient to raise what's known as a mistake of fact excuse or a mistake of fact defense. If the defendant raises this mistake of fact defense, the prosecution then needs to disprove that. In other jurisdictions, it's different. The prosecution needs to prove that someone had the right mens rea, guilty mind, that they were mentally culpable at the time when it came to the offence. And we'll deal with that one first because I feel like that's the easier one to understand. So in New South Wales, Victoria, South Australia, the ACT, and the Northern Territory, the prosecution needs to prove that the defendant had knowledge of non-consent at the time of sexual intercourse to prove the offence of rape. Now, this knowledge of non-consent can be actual, that is, they did know that the other person wasn't consenting, or it can be constructive. So we can recognise under law that you should have known, basically, at the time. Now, without going into too much detail into these, there is some variation across states and territories about what level of knowledge a person has, but it can encompass things like actually knowing that the person is not consenting, being aware of the possibility that a person is non-consenting, it's known as advertent recklessness, not considering whether someone is consenting at all, inadvertent recklessness, or someone actually having a belief that someone's consenting, but this is not a reasonable belief. So the kind of mental state that the prosecution can prove, it's a lot of different things. It's not just that someone actually knew the person's not consenting. It can also be some of these other things where they haven't even turned their mind to the idea whether or not someone's consenting. The important thing to note about this element is that intoxication, whether it's with alcohol, whether it's with methamphetamine, or whether it's with other illicit drugs, cannot be taken into account in assessing that mental state. So you assess whether or not someone has this knowledge from the perspective of a sober person. Someone's methamphetamine use at the time of perpetrating the offence won't be taken into account in determining whether or not they had the appropriate mens rea or guilty mind for the offence. In Western Australia, Tasmania, and Queensland, as I said, you only need to prove that the act occurred and that it wasn't consensual for the offence to be made out. However, there is a defence or an excuse available if the defence raises an honest and reasonable but mistaken belief that a person is consenting. If that's raised, the prosecution then need to disprove that beyond reasonable doubt. Now, similarly to other jurisdictions, when it comes to that guilty mind element, when determining whether or not someone had an honest and reasonable but mistaken belief that a person is consenting, in Tasmania and Queensland, legislation makes it very clear that self-induced intoxication with alcohol or other drugs, including methamphetamine, cannot be taken into account in assessing that. In Western Australia, it may be taken into account in some circumstances, but it's quite a complex area, and that is likely to change relatively soon. So you can kind of work under the assumption that intoxication overall is not going to be taken into account for this defence in any part of Australia. A couple of just some extra points here in terms of affirmative consent jurisdictions, the ones we were talking about earlier. They also note that for someone to avoid having the guilty mind at the time of the offence, or to be able to use this honest and reasonable mistake of fact defence, the affirmative consent jurisdictions actually say that the defendant, the accused, needs to have taken some steps to ascertain consent at the time. If they did not do that, then they would have had the guilty mind. They would not have had an honest and reasonable belief of consent. So I thought it's worth noting that. And then the final thing that I just want to note is some of you might be noting, well, if somebody's using methamphetamine and they have developed psychosis or psychotic symptoms, could they use the insanity defense? The general answer to that is no. So the way the insanity defense is defined in all states and territories is that they exclude symptoms as a result of self-induced intoxication. Now, this gets a little bit tricky with methamphetamine because there is a distinction under law between someone who has a pre-existing mental health issue that is exacerbated by methamphetamine use and someone who just exhibits psychotic symptoms as a result of their methamphetamine use. If you've just developing those symptoms because of your meth use, the court the insanity defense doesn't apply. If you do have a pre-existing mental health issue, it may apply in some circumstances. All right, so that was a lot of law, and hopefully that wasn't too overwhelming for you. But just to kind of bring it back to those questions that I raised at the start of the webinar, can I legally consent to sex whilst high? Well, yes, you can. Being intoxicated with methamphetamine does not in itself mean that you do not consent. However, if you are incapable of freely and voluntarily agreeing to the sexual activity because of your methamphetamine intoxication, then the law will say that you did not consent at the time. To the question, can I still get in trouble if I was high at the time? Well, potentially yes, because self-induced intoxication is not taken into account in assessing culpability. And to the question, what if we were both high? Well, the law applies differently to the complainant or the victim versus the accused or the defendant here. Intoxication can be taken into account and frequently is taken into account in determining whether or not the victim consented. Intoxication generally is not taken into account when assessing whether or not the accused or the defendant is culpable. All right, I hope that was an enjoyable overview there, and I'll throw to questions.
Yeah, thanks so much, Jared. That was really interesting, and we appreciate you providing some education around the laws on that. It's obviously quite complex and different between states and territories. Mm-hmm. And I know that for methamphetamine use offences, it's also different between states and territories. Do you feel like that's something a lot of people know about? Do they realise that, say, they go to a party in a different state, that the laws are actually different in that state?
I do wonder. It's always, in many respects, I never know how much I've been lawyer-brained and I don't quite understand the general public. But I think potentially when it comes to sexual consent, I imagine many people, because of media consumption, probably were under the understanding that every state and territory in Australia has an affirmative consent model, mainly because that's the kind of conversations that we often have. And certainly, as I said at the very start of the webinar, I think an affirmative consent model is probably the morally correct model, but there is a difference between the kind of moral standard versus the legal standard. But yeah, it does differ greatly. One of the things that is going to potentially come out of that federal inquiry is a uniform sexual consent law. So we could have from that inquiry a uniform standard throughout Australia, which might help things.
And would that be kind of like a minimum standard that then each state and territory could kind of add on, what they want on top, or would it just be like a blanket, this is what we do in Australia?
The idea is that it would be consistent, and that is one of the potential criticisms of a uniform standard, is that we could potentially have everyone agreeing to a less comprehensive standard. So if you look at some of the submissions to the inquiry, that has been raised as a potential risk to trying to create this uniform standard.
Yeah, for sure. And do you think the terminology will also kind of be unified at the federal level? Because I noticed there's quite a lot of different definitions as well within the states and territories, which I'm sure does not make it easy on lawyers or health workers or anyone trying to understand this space.
No, I think it particularly the case because lawyers obsess about minor variations in words a lot as well and can argue about those different things. Yeah, the fact that, how the threshold of intoxication is worded varies greatly, that even that freely and voluntarily given, so sometimes it's just free agreement, sometimes it's free and voluntary, for there to be a kind of ideal of consent under the law, I think we probably do need some consistency in wording. Yeah. It
would probably at least make it easier for the people who aren't lawyers and don't have the lawyer brain. There's quite a few questions that have also come through around if someone does report a sexual assault incident and it happened while everyone was under the influence of drugs, would the police actually charge you for that illicit drug use based on your self-disclosure? So are you, running the risk of getting in trouble essentially if you...
Unfortunately, it would be up to police discretion in the vast majority of states and territories. The exception, of course, is the ACT, which has now decriminalized small quantities of methamphetamine. So that is a real case for decriminalization of possession and use. And it's not just within the context of sexual violence, but in a lot of different contexts, we have a situation where criminal behavior has happened and people are reluctant to speak to police. People are reluctant to even act as a witness to police because they're worried about being charged over their drug use. So unfortunately, it would depend on the police and it would be within that scope of police discretion.
Okay. Thanks for answering that so honestly. Someone was asking what kind of pre-existing mental health conditions would allow for the use of the insanity defense?
So it would be anything the three cases that I can think of at the top of my head that used methamphetamine were a diagnosis, all of them were a diagnosis of schizophrenia. I imagine you might be able to mount an argument on the basis of bipolar disorder because of how manic stages interact with methamphetamine use. But yeah, the only ones that I'm aware of involved someone with a pre-existing diagnosis of schizophrenia that was exacerbated by methamphetamine use.
Okay, so they really look into the sort of pre-existing conditions.
Yeah, and I know that that's the law is not always in keeping with the kind of the best research in an area, because I know there's a lot of research now about, you know, whether or not people who develop psychosis as a result of methamphetamine use actually have a prodromal condition or something. Unfortunately, the law is not recognizing that complexity. Yeah.
Oh, interesting.
Yeah.
Someone's asking how is the level of intoxication assessed after the fact?
So most of the guidance we have for this is in relation to alcohol. And so it relies on witness accounts of outward behavior. So slurred speech, actions, whether or not someone was fully conscious or they were nodding off. So it has to be inferred externally. There are cases to say that merely having gaps in memory the day after isn't sufficient to say that you were substantially enough intoxicated the day before. So it does rely heavily on, I guess, external witness testimony and also the testimony of the complainant or victim at trial about what they felt, the level of intoxication that they were at. Right.
And so there's no particular, I guess it depends on how soon things are reported, but, you know, there's no sort of blood testing or kind of urine testing to look for methamphetamine levels or any other drugs, really.
Some cases of alcohol, they might have levels of alcohol. Vast majority of cases with reporting of sexual violence, it's usually days after the fact. And so that evidence, you know, rarely comes up in trial in my experience.
Yeah, well, I guess if it's a few days after the event, you know, a lot of the drugs have been washed out of the system and be impossible to detect. What if someone is on a forensic order?
So we're talking about a situation where someone is on a forensic order because they're mentally unfit, or?
I think so, because all I've got is forensic order, and sadly I'm not an expert in the area. But
I mean, I'm not either, but if we're talking about a situation where someone is under community supervision on the basis of their mental health issue,
yes,
is there further information?
Followed up with yes, like a long drug history. So I assume it's like a community forensic order.
Any evidence, and is this in relation to whether or not an insanity defense would be raised?
No, separate question.
Okay. I think in terms of the elements of a rape offense or something like that, someone having a pre-existing serious mental health issue could be raised in terms of lack of consent, as we said, because of that threshold of capacity. And in terms of an accused who has that kind of history, whether or not they have an insanity defense available would depend on, the severity of their illness. But yeah, the existence or non-existence of a particular order, I can't see as necessarily telling anything about how the elements would apply in practice.
Right. Okay. I guess it would be something that would be looked closely at in that situation.
Yeah, and I mean, everyone's individually assessed.
Yeah.
And also, remember when we're talking about these capacities to consent or not consent or knowledge and things like that, it's trying to, as best as you can, infer at that particular moment, at that particular time, those mental states. So how useful history is going to depend on what was happening at the time.
Yeah. A slight deviation is what if someone is provided substances without their knowledge, or in the case that, say they agree to take methamphetamine with someone, but they end up taking a much higher dose than what they agreed to. What kind of impact does that have around their consent?
So in consent, whether or not the intoxication is voluntary or involuntary for the purposes of whether or not someone's consenting, it doesn't matter. I mean, if they're intoxicated to that point, they're not consenting. There are separate offences for providing an intoxicating substance to a person in order to facilitate a sexual assault. Okay. So those offences potentially come into play. Where that scenario is particularly interesting, though, is in terms of the accused or the defendant, because as I was saying, voluntary intoxication isn't taken into account in assessing that guilty mind. However, non-voluntary intoxication can be taken into account in assessing that guilty mind. So if you, and in both of those situations would apply here, if you've not planned to take a drug and someone has drugged you, then you've committed a sexual offense, very likely that your intoxicated state at the time would be taken into account. And it also applies to that levels of purity within reason, of course, because everyone who's using an illicit drug probably accepts a degree of, levels of impurity. But yes, so there is a distinction between voluntary intoxication and non-involuntary intoxication in terms of the accused.
And what about, so before you take any sort of substances, what if you agree to have, consensual sex with your partner and then you become intoxicated? What does that have any impacts on that sort of what happens next?
Yeah, so our model of consent that the criminal law recognizes is ongoing. So you can have a situation where someone agrees to, use meth together and we're going to have sex, and that was all very clear. But if at a certain point somebody becomes so intoxicated that they cannot consent, the law just says, well, at that point they cannot consent, and so an offence could apply. Right. So you can't kind of pre-agree to being non-consenting later on. Right. Yeah, it's an ongoing process, and the law and a lot of cases put a lot of emphasis on this idea of someone's capacity to withdraw consent. And that ability to withdraw consent, if you get so intoxicated that you can't withdraw consent at any point, then the offence is committed because you cannot consent.
Okay, yeah, that makes sense. And in terms of these laws, do they also apply to people who are incarcerated or in the prison system at all? Criminal justice system, I should say.
Yes, 100%. In terms of criminal offences apply in the prison system just as equally as outside of them. Absolutely.
Okay. I'm just also looking through some of the answers. Some of the questions. There's quite a few. Everyone's very interested. You've done such a great talk, Jared. What do you think, will there ever be any consensus across the states and territories about the laws becoming federal? Like, is this something that we think is reasonably going to happen in the near future?
I think if you look at so I've looked through all the submissions to that federal inquiry, and I think one thing that is indicative that that's less likely to happen is that each submission seems to have a different model in mind about what the ideal consent law should be. You know, some people are very in favor of these affirmative consent laws. Some people like that mistake of fact excuse approach versus the prosecution having to prove a guilty mind. And I think the fact that everyone disagrees to some extent about what that model consent law looks like is a bit concerning, and might be the reason why we're less likely to have a model consent law federally. So I don't know. We'll see in September, obviously.
Yeah. I guess. Yep. We'll have to see what September brings us. I do have another sort of left of field question, and this is about the law in relation to sex on premises venues.
Yep.
So when it comes to rape or sexual assault cases that have happened on those venues, I guess the laws don't really change, but
no, they don't.
You know, is there some sort of, does that have any impact, I guess, on the outcomes of your sort of cases?
I imagine, you know, what that question is getting at is, and I've written a bit on this, is you know, sex on premises venues, particularly for gay and bisexual men, tend to have their own dynamics at play, particularly around consent. So there's often a kind of very non-verbal, very kind of physically driven way of negotiating consent. And I think in jurisdictions of affirmative consent, it probably wouldn't, a lot of the sex that happens in those venues probably wouldn't reach the threshold of affirmative consent. That's kind of a reality. And so that raises a whole bunch of issues within sex on premises venues. The law applies equally in those venues. And the mix of, you know, methamphetamine use and sexual activity in those venues is fairly prevalent as well. So that raises interesting issues. I should note as well that sex on premises venues often have particular occupational health and safety obligations as well as unique venues, including taking active steps to prevent sexual assault and sexual violence on those premises. And so I think if somebody runs one of those venues or frequently attends those sorts of venues, you need to be aware that the criminal law just equally applies there, even though it does kind of challenge some of the cultures within those venues. It just applies equally.
Yeah, okay, that makes sense. In terms of reporting sexual assault, often, as you said, it might not happen for days, months, years. What about, you know, reporting a sexual assault and drug use? What are your thoughts around that? Like, is it, if you report years after the fact, you know, is your case still, I guess, valid? And
I think the first thing to emphasize is that there's no statute of limitations when it comes to serious criminal offences like this. So it is not a case that, you know, it's not prosecutable because of time past. So when it comes to historical sexual offences, where the difficulties come for prosecutors with historical offences is, of course, kind of witnesses and evidence and those sorts of things. Saying that, there's been quite a number of historical sexual offence prosecutions in Australia, certainly following the inquiry into institutionalised child sexual abuse. We saw a huge wave of successful prosecutions on the basis of sexual offences that had occurred decades prior. So certainly whoever's asking this question, if they have concerns about, you know, time passed since a sexual offence has occurred, there is no strict rule excluding it. There's no statute of limitations. And we have a lot of good evidence of recent successful prosecutions as a result of focusing on historical sexual violence. Okay,
great. Thanks. It seems to be the day of left of field questions.
I'm up for it.
Considering the high incidence of bloodborne viruses, so we're talking about HIV, Hep C,
yep.
And even not a bloodborne virus, but say a pregnancy, you know, what happens if that sort of gets thrown into the situation? Like, is there, you know,
well,
say,
so
because of the sexual assault you contracted or you became pregnant?
Not for the prosecution of rape or sexual assault. However, there are particular offences that apply to intentionally transmitting a communicable disease in all states and territories that might apply that offence. There's been attempted prosecutions for intentional transmission of HIV for other offences, including sexual offences, and the law has recognised that, well, no, consent to sex involves a consent to the risk of sexually transmitted infections. So for a sexual offence, it's not that relevant, but there are separate offences that could apply if someone has intentionally transmitted an STI.
Okay. And this one's more an advice one. So within the current legal and justice system, and this person's specified for New South Wales, what would be the best way for people who use drugs to protect themselves when experiencing sexual assault, while it's up to the police to press charges? You know, what can they do to protect themselves?
So, I mean, there's a couple of thoughts come to mind in terms of, you know, we use that term harm reduction a lot, and that's kind of a good term in terms of if you are engaging in sexual activity involving drugs. I think there probably needs to be good community education and good understanding about, you know, when someone's reached a point where actually no, you know, even if that person seems to indicate that they want to, you know, and it's a bit unclear, there needs to be a consensus amongst people who use about there being a level in which, no, someone doesn't consent and I'm going to stop doing these sorts of things. Certainly engaging in that type of activity, which is often the case in groups, can maybe assist in that, and that people can kind of look out for each other, and where dynamics of potential offences come into play, that there is some sort of bystander intervention. If a sexual offence has occurred, and I think that the question is slightly getting at this situation as well, where a sexual offence has occurred and someone wishes to report that to police, how can people protect themselves from, say, a drug offence charge and those sorts of things? I think I can't confidently say that there's some sort of magic, you know, immunity in those situations, which means the police can't charge someone. It is the case, though, that sexual assault investigations are undertaken by different kinds of police than drug police. And so the cultures around that are a little bit different. And I imagine a lot of people, of members who serve within that sexual assault investigation unit would probably tell you that they're not going to bother looking at, you know, drug possession, drug use type offences if a more serious offence occurs. Unfortunately, there's no law saying that, and that's dependent on the police discretion, as I noted earlier.
Yeah, okay. Just back to my earlier question, in terms of when we're talking about, you know, if someone intentionally tried to give someone HIV, what if, and then this might be quite a grey area, what if someone intentionally got someone pregnant?
So if that was the result of a removal of a condom, we have specific law reforms to deal with stealthing, and they talk about that the nature of the sexual activity can include with or without a condom. So if someone is misled about the nature of a sexual activity, they cannot consent. Wow. So so stealthing is not allowed under Australian laws where the condom is removed. Other circumstances, I mean, people talk about consent within the context of somebody saying that they're on birth control when they're not on birth control and those sorts of things. No idea how that would play out in law, to be honest.
Okay.
Yeah.
Thanks. And what about mistaken identity? So if someone says that they are HIV negative, for example, but they're actually HIV positive.
So it's again a tricky one. Again, the limited cases that we have on that indicate that the fact that somebody is HIV positive and doesn't disclose it doesn't negate sexual consent. you're still opening yourself up for a separate offence, as I said. That criteria of identity and the identity of the person is an interesting one, because it probably hasn't been tested in terms of its scope enough under the law. So it's generally applied to situations where somebody says that walks into a room and it's dark and pretends to be the boyfriend of the victim or something like that, where there is a mistaken identity of the person involved. It doesn't involve superficial characteristics of character, so someone lying and saying that they are a millionaire when they're not a millionaire. That doesn't negate consent. So we have those kind of two extremes, right, about what occurs there. And there is a lot of ambiguity in the middle. One thing that I've written on recently, which is a bit interesting, is there's been a number of UK cases talking about trans people and whether or not trans people need to disclose their sex assigned at birth as part of obtaining sexual consent. In the UK, there's been prosecutions on the basis of that. We haven't had anything like that here. But again, because that identity category hasn't been tested that much, I can't actually say, at what point is a mistaken belief about someone's identity sufficient enough to mean that someone can't freely and voluntarily agree. That would be how the case would need to be made out. So that was kind of a non-answer to the question, in that it's ambiguous a little bit about this identity category.
But I guess one thing we're kind of getting throughout this whole webinar is it is very case dependent and situation dependent.
Yes. And if you think of that ideal of free agreement, that's what it all comes back to, right?
Yeah.
Did the circumstances mean that someone cannot freely agree to the sexual activity? That's how any case to do with that element of non-consent will be based on.
Yeah, okay. Well, that's probably a good place to wrap it up. There was quite a few other questions, so sorry to anyone who didn't get your question answered today. We're very happy for you to email it through to Cracks in the Ice, and we can pass it on to you, Jared, if you'd like.
Yep, that sounds great. Yep.
And also, just to finish up today, again, thank you so much, Jared. I know that it was a really complex area, and when I asked you to do this webinar, you were a little bit like, what do you want from me, Steph?
Hopefully I didn't overwhelm people, but yeah.
We really appreciate all your thoughts and your education around the space. And everyone's been really engaged today, so thank you.
Thanks for having me.
Anytime. For the audience today, thank you so much for being part of this webinar, and please feel free to check out the Cracks in the Ice website. We will be recording this webinar and putting it on the website to watch on demand, so please feel free to share with anyone that you think might be interested. We'll also be regularly updating the site as well. And just a reminder to take care of yourselves. If today's talk has brought up any concerns or issues for you, there is support available. So please reach out to Lifeline on 13 11 14 or 1-800-RESPECT. And there's also help services listed on Cracks in the Ice as well. So thank you again, everyone, and I hope you all have a wonderful rest of the day. Thanks.